Hi, everyone. Attorney Rachel Gruetzner here for another Family Law Friday. This week, I'm answering the question of why should I involve an attorney in my divorce if me and my spouse agree to everything? So I hear this from people a lot. They feel like an attorney is too expensive and not worth the cost if they and their spouse have sat down at their kitchen table and resolved everything in their divorce. And it is great that you and your spouse have agreed to consciously uncouple and that you are ready to move on in a way that you're both happy with what you've agreed to and how you've resolved it. However, if you and your spouse share minor children in common or have any joint debts or joint assets, such as a car or a house, or if you have retirement accounts, you should never get divorced without an attorney either preparing your final judgment of divorce for you or at least reviewing the judgment of divorce that you've written for yourself. And the reason for that is because your judgment of divorce is a living, breathing contract. What it does is it tells the public not only that you and your spouse are no longer married, but it also defines what your rights and responsibilities are and what your spouse's rights and responsibilities are. And because it's a piece of paper, if the two of you and in the future, at any point in the future, do not agree about what the words on that piece of paper mean, then the words on that piece of paper become incredibly important. If you and your spouse choose not to involve an attorney whatsoever in finalizing your divorce, and you write your own judgment of divorce, there is a 100% chance that you're going to make some sort of mistake in that paperwork that will cost you something in the future. And sometimes that cost is financial, and it's the cost of paying an attorney to go back to court to fix the mistake. But sometimes that cost is simply a complicated emotional toll or the time for your labor to get something done that you otherwise might have expected your spouse to assist with, but the judgment of divorce doesn't say that they have to, and so they just simply won't do it. I want to give you a quick example. So many couples who try to divorce on their own have an agreement that says that, oh, we'll close the joint bank account, or one person is going to get the joint bank account over the other. Well, when are you going to close it? How are you going to close it? Who gets it? When do they stop having access to that joint account? I have heard horror stories of people who were getting along just fine and dandy when they filed that judgment of divorce, and then a year later, they find out, oh, we still have this joint bank account that we never closed. It's been sitting here earning interest, and now we don't know who that money even belongs to because we didn't put it in our judgment of divorce. So if you and your spouse are working well together at the beginning of your divorce, that is a great thing. And that is the prime time to involve an attorney and pay an attorney a fraction of the cost that you would pay them for a dispute later to make sure that your paperwork is correct today. Listen, I am all for clients saving as much money as possible during a divorce, but it's also my job as an attorney to make sure that my clients are protected not just now, but as far into the future as possible. If you and your spouse have come to an entire agreement about how to get divorced, but you want help making sure that your final paperwork is in order, give us a call. We'll be happy to talk with you about our limited scope representation options.